Hi, welcome to IP Ethics and Insights. I'm Mike McCabe. With me is my partner, Emil Ali. And today we're going to be discussing the top things every law firm should have. Whether you're an existing law firm or you're thinking about starting a new law practice, these are aspects and practices that every law firm needs. Emil, why don't you start us out?
So, other than having a great fireplace, a lot of law firms should think about the structure that they should have. So, one of the foundational elements that I think every law firm needs is documentation. And we can get into documented practices, but starting with the foundation of a client engagement letter, right? So, we want to see not only an engagement letter that's actually something that's been hopefully signed by the client or agreed to by the client, but also something that documents the whole relationship, right? We want to see what the scope is. We want to see how much is being charged. Hopefully, if there's not a problem, but if there is one, there's arbitration or mediation, whatever those constructs might be. But also make sure that it complies not only with the USPTO rules, but also with the rules of various states.
Another aspect that every law firm needs to have is a very strong conflict of interest system. And this is going to be critical because one of the leading causes of legal malpractice in the United States is actually for lawyers who engage in conflicts of interest. So to set up a conflicts of interest database, you need to know and keep track of not just the identities of your clients as well as opposing parties, but also you need to think about who is your client. If your client is an organization and it's an institution, are you representing one entity within that organization? If it's a multinational where it has many subsidiaries and affiliates, are you representing select few of those, or are you representing the entire corporate family? That's going to be an important aspect of any conflict of interest checking. For intellectual property law firms, another important aspect critical to have for your conflict checking system is a subject matter conflicts checking system. What is subject matter conflict checking? Well, that means in USPTO's terminology that means the situation where an IP lawyer is obtaining patent rights or trademark rights for one client that is very similar, if not substantively identical, to the rights that the same lawyer or law firm has already obtained for a different client or is seeking to obtain in parallel. So making sure one understands whether or not the subject matter of, let's say, a trademark application for a new client, that you're not actually seeking to register a mark that's substantially the same as a mark for another client in the same or similar goods or services. And the same on the patent side too. We want to look at the scope of the claimed invention for your client and determine whether or not you have worked on any other client matters that involve the same claim scope of protection for those inventions as part of a robust conflict of interest checking system. Another requirement for an IP firm and all law firms really are strong docketing practices. What are some of the aspects of strong docketing practices that you see?
So, like there's not one size fits all approach, just like for conflicts. There's not one size fits all for docketing. There's a lot of different software and services out there that are great. Some only excel in patents and some only excel in trademarks. But one thing that you and I have learned over the years representing people is that a pen and paper system is not the docketing system that you want to have, right? A marker board, none of that. If you love pen and paper, fine, right? I love checking off things off a list. I like that physically, but I still have a backup system, some sort of electronic system, whether it's your CRM, whether it's your Outlook calendar. You got to have belts and suspenders because outside of conflicts, missed deadlines are a very, very big problem. And I think you and I both share the belief that things like maintenance fees, right? Renewals, they tend to be high risk, low reward services. And that's why a lot of big law firms are moving away from those, sending those to annuity companies. And, for good reason, because docketing is very, very important. And even if you do have belts and suspenders, you can still make a mistake.
Right. Another important fundamental aspect of a strong law firm practice is having timely client communications. One of the number one reasons that we see for clients who object or complain about their lawyers is failure to communicate. My lawyer didn't return my phone call. My lawyer's not responding to my emails is a very common bar complaint. And the bar takes those complaints very seriously. The order to have a strong management system and a structure in your firm, you need to have systems in place to ensure that you know when communications are coming in that require client communication and discussion, and that you have a docketing system set up tied in to your communication system so that the two work really hand in hand, and you know that you're sending out communications in a very timely manner. So for example, when one is dealing with the patent and trademark office, you're used to dealing with a lot of deadline driven communications. And so you'll make a filing that's due by a deadline. You'll have an obligation to have your docketing system docket that deadline, and you meet that docket. And then your communication system tells you to remind you to send a client notification, item docketed. When a response is received from a bar or from a patent office worldwide, or even from a court, you're going to have deadlines associated with that. And you're going to want to docket into your system not only the actual filing deadlines, but some dates building up to that. If you have a 90-day deadline, you might have a 30-day and a 60-day, and then the absolute drop dead date for your meeting your deadline. And with those docketing reminders, you'd want to send out communications to the client to make sure that the client is also receiving these important communications that require client consent. If it didn't happen in writing, it didn't happen at all. And you really don't want to get into a situation where you're having to rely upon memories about oral communications about important things. So if it's an important communication, even if you're discussing it with your client orally, you should always make it a practice to document that discussion, conversation, and memorialize that conversation for your own protection.
So, one thing I'll jump onto that. If it's not in writing, it never happened is very true. But what I like to tell people is the way I over communicate with my family, right? I want to make sure that my son does get something done. I have to keep reminding him. I have to keep communicating with him. And when you're in the patent system or the trademark system where pendency is over a year, sometimes you have to communicate nothing. You have to communicate the fact that nothing has been done. And that's a good way to keep a happy, client. Just like, we might say happy wife, be life, happy client, no bar complaint.
We need to find something that rhymes
Yeah.
with client. Um, Supervision and training for attorneys and non-attorneys is also a hugely important aspect of any law practice. If you are unless you are the one attorney that doesn't have anyone else who works for them inside or outside the firm, um, you're typically going to be involved in a situation where you're going to have supervisory responsibilities with respect to both non-attorneys, such as support staff, paralegals, secretaries, legal assistants, law clerks, and you're going to have supervisory responsibilities potentially as to other lawyers within your firm or within your practice. So a strong commitment to supervision is going to be a really foundational requirement for solid law firm practice to make sure that proper training and oversight is being provided to the attorneys and the non-attorneys in the firm. That from our perspective as ethics lawyers, law firms are required to have in place systems and processes sufficient to ensure that the lawyers and the non-lawyers in the firm are are abiding by the same rules of professional conduct that the lawyers themselves are required to abide by. And so this involves education and oversight with not just the paralegals and the non-practitioners who you can assume don't know anything about the ethics rules, but also regarding um, your legal staff as well, your trained lawyers. Lawyers even have 20, 30 years plus experience, often will still require some supervision, some support to ensure that they're maintaining their competencies and the level of the law, that they're maintained on all of the requirements, because one thing that we do know about the legal practice is it's constantly evolving. And as an old dog, and it is difficult to learn new tricks as an old dog, but as a lawyer, you're going to have a responsibility, even when you're an old dog, to learn new tricks. And new tricks could mean new technologies, but that can also mean new legal developments. And so we all have an obligation to maintain our competency, but that's also embedded in the idea of supervising those and wanting to provide supervisory support to the lawyers and the non-lawyers below us.
Yeah.
Another important aspect to have that you're going to need to have for your law firm is a trust account. You do a lot of work with our trust account. Why don't you discuss the trust account
Yeah,
issues?
so trust account issues, especially because I represent a lot of folks in California as well, that's become a really big thing ever since the Girardi scandal. So California has taken a very aggressive approach to trust accounts. So how does that impact patent lawyers and trademark lawyers? Well, generally, if you take money in advance and it's not earned, you must put it into an account that's separate from your own. Depending on state law, it may require you to put it in even more special account, like an IOLTA account, an interest on lawyers trust account, in which the interest from that goes to like a state bar access to justice program. So what's really important for us as patent lawyers, as IP lawyers, is to make sure that we follow at least one of those rules, right? So for practice before the office, generally it's going to be the USPTO rules. So you must have some sort of trust account if you're taking money in advance. And if you asked me when I was in law school if I would ever have a trust account, I'd say no. I'd say I wouldn't take money in advance. But we know the story. We know the story about how everyone ends up saying, you know what? I need to collect XYZ in advance because I don't know if this company that we're filing a patent application for is going to be around 2 years from now. So if you're going to take money in advance, try to create some sort of retainer program, whatever it might be, make sure that you have a trust account and look at the law of the state in which you operate from, where you're licensed and where your business is really run from.
And this is a really important point too, because these are trust account rules also apply to patent agents. And now the US Patent and Trademark Office permits patent agents to own and operate their own law firm. Patent agents are also required to hold trust accounts. When they're receiving funds in advance, those accounts must be held in a trust account. But if you're a patent agent and you walk into your local bank and say, I want to open up a trust account for my law practice, they're going to say, okay, well, where are you licensed to, what state are you licensed to practice law in? And you'll tell them, well, I'm not licensed in any state. I'm registered to practice before the USPTO. And they're going to say, well, I'm sorry, we can't help you, or something like that, because the banking system isn't really set up to know what patent agents are. Well, that doesn't absolve you from your responsibility for having a trust account, even though the bank personnel might not understand that you, as a non-lawyer, still have an obligation to have a trust account. So we have worked with clients who are patent agents before and have helped them get trust accounts set up for their law firm. So just keep in mind that whether you're a patent agent or an attorney, a trust account is going to be required anytime you receive funds in advance. And this is also true, particularly when a lot of our clients receive expense funds in advance. And as you know, in patent practice, especially and in international practice, you can have thousands of dollars in out-of-pocket expenditures. Some law firms have the bandwidth, financially speaking, to carry that debt and bill the client, but many firms just don't have that ability to do so, and they require payment in advance. Again, it's necessary, whether it's 2 weeks in advance or 3 months in advance, it must be separated from funds that are earned. Until those funds are earned, they must stay in the trust account. Once they are earned, then they have to be moved from the trust account into the law firm's operating account. So that's all we need to say right now about trust accounts. How about insurance? What do you think about obligations for lawyers and insurance?
So, very few states actually require you to carry insurance. I believe right now it's only Oregon and Utah require you to have insurance, and Oregon just has a mandatory insurance program. But many states require you to disclose either to clients or the bar whether or not you have insurance. But from a very candid perspective, Would you ever drive a car without having insurance? Right? Would you buy a house without insuring it? So why would you do what probably is the biggest, investment in your life, having a law firm? Why would you operate a law firm without insurance? So, you
Well,
know,
cost,
well,
right? Isn't that the,
fair question. It's a lot less than you think, right? If you have a good record, a good track record, you could generally buy a policy. I mean, $1 million policy is probably the minimum. You can get obviously less, but you probably shouldn't be getting less than 1 million. But for a few $1,000s, right? It's actually interesting. Malpractice insurance for patent lawyers actually tends to increase as the years of experience go further because of the long tail of risk. But beyond malpractice insurance, there's also things like business owners liability insurance, et cetera, but also cyber insurance is another
yeah,
big one with social engineering scams, wire scams, all that. It is really important to consider it. At the bare minimum, get malpractice coverage, cover, whatever you want to call it, but consider other types of coverage as
right,
well.
right. And last but not least, you've got to have an understanding of the regulations that govern the practice of law, and there are many of them. And we live through this day in and day out as to whether we are dealing with our clients, we owe duties to our clients, we owe separate duties to opposing parties and non-clients, we owe duties to tribunals and courts and agencies, we owe duties to the public. Uh, and so understanding all of these duties and understanding whether your practices and procedures are compliant with those duties, it's not always that simple. It's not always easy to pick up the rule book and open it up and say, oh, here's the answer is very clear, black and white. And so it's good to have in-house available expertise or subject matter expertise into the rules of professional conduct governing your firm's practice so that they can institute controls that are risk management controls, including adopting the types of policies and practices and documentation that we've spoken about here during our fireside chat, but having those all as part of a comprehensive package of of of, of risk management policies and procedures will only serve to benefit to protect your firm and yourself from liability, protect your clients from potential harm, as well as protect yourself from risk to third parties and to the public, as well as complying with your obligations to the bar and all of these people and entities who we owe duties to. All of those issues it can be very tricky and complicated. So you need to have a good managed system that oversees those issues, but also you have to have the ability to respond pretty quickly to a changing set of facts. Oftentimes, ethics and risk management issues come up very quickly, and a client or prospective client will need to know an answer right away. You need to have resources available at your ready so that you can ask counsel, uh, educated counsel for guidance on this. Some bars, like Virginia bar, has an ethics hotline where you can call and get free legal advice. Oftentimes you get what you pay for, but sometimes you will get enough of information from bar counsel. Uh, Even some malpractice carriers offer the benefit of having to get consults with ethics or risk management counsel as part of their programs, but also just in general, whether it's through insurance or privately, you can find in-house or outside counsel like us who can help you answer questions and address issues as they come up involved in as they come up in real time and really as they relate to the integrated package of your law firm and whether you're appropriately measuring and controlling the risks associated with your practice. Now, that's all for this segment of IP Ethics and Insights. Thanks for joining our fireside chat.